Hi, I'm Marc Stevens, author of Government Indicted, website marcstevens.net. Got a great video here today. I'm going to try to keep this as brief as we can. We're going to completely debunk a prosecutor's response. Okay? So if you've ever, and I know a lot of people feel intimidated by attorneys because prosecutors or not, they're spending all day in court. They know the system backwards and forwards. They know, they've been to law. They have a doctorate degree, for heaven's sakes. Don't let that intimidate you. When they attack you, the foundation of their claims is never going to have evidence and can't. Because the foundation of a prosecutor's claim is that, and here we're going to be discrediting and debunking a Canadian prosecutor again, because the foundation of the prosecution's case, and they'll tell you, you've heard the call of shames, and we have plenty at marcstevens.net where they're actually agreeing, no one's disagreeing with this, that the foundation is if you're physically in Canada, their laws apply to you. In fact, when I go through, this prosecutor will agree to that. Again, this is not something I've just pulled out. This is their own admission, and it's in the document. We have the proof, as if we needed more proof. So don't feel intimidated by these people. It's very easy to see through and discredit what they're doing and to call them on their BS. Very easy. And this is just another example of that. So this is, again, another prosecutor in Canada who can't prove the Constitution applies to anybody. So if you remember, and I'll have linked in the article, there was a Canadian prosecutor that I spoke to. She would not be responsive. I asked her the question of the evidence. She wouldn't be responsive. She said I had to put in writing, and keep in mind this is a prosecutor because this is an active criminal prosecution. And it was a discovery request, which even in Canada, they have, it's not called Brady, but they are legally required to give you all impeachment and exculpatory evidence that they have. And they don't do that. So, she insisted I put in writing. She was the one that said, when I asked, because I'm not stupid, contrary to what the critics will tell you, I know the difference between when someone says they're going to respond and if they're going to be responsive. You can respond with anything. Doesn't mean that you're answering the question. So you can go back in the article, you can listen to that call of shame. So it took a couple of months to get an answer for evidence proving the Constitution applies. Months. And they had to assign another attorney to it. But when I called him, he hung up on me pretty fast. He didn't like that I said that his letter that I'll post in a couple of minutes was a form letter, but you'll see for yourself it's a form letter because there's a very serious due process violation on just one part of it, but we'll get to that. So the letter, so that we know how to properly debunk this crap, you have to see the letter that he's responding to, of course. So per your request on the phone today, I put my request in writing. I know you and the CRA, the Canadian Revenue Agency, believe that if I'm physically in Canada, then your constitutional laws apply, and that is the basis of the government's alleged jurisdiction over me. My question is, what evidence, that is specific facts, do you and the CRA rely on to prove your claim is true? You are very resistant on the phone and would not confirm you would be responsive to my question, only that you would respond. That's how you know you got a dishonest person. Please be responsive and address this question of fact. It's not an argument. It's not an issue of law. I am not a sovereign citizen of Freeman or any such type. Do not cite court opinions as opinions are not responsive, and at best an appeal to authority. Please do not waste my time citing the Meads case that only dealt with theoretical issues of law. Do not give legal citations as they are non-responsive to a question of fact. And this is the due process violation I was talking about. That's why you don't do copy and paste form letters, because you miss things like this. Please provide the names of any CRA employees you may rely on and provide direct contact information. So it's like if a police officer gave you a ticket and you couldn't read his name, and you asked the prosecution for the cop's name. Who the hell's the witness against me? And they blow it off. They have to give you that. But they don't. They don't like to. Okay, well in tax cases they really don't want. They don't want that tax agent on the stand. Okay, so here is the response that I got. And we'll go through this one line at a time and debunk this trash. You can see right from the very start, he claims you can't explain the law's application without referring to the law itself. We've seen this 1,000 times. The laws apply because the laws say so. Circular logic, yes. That is our first logical fallacy. The text of the law is completely irrelevant until you can prove it applies. And saying that it applies because it said so, you may be invoking Odin, but that doesn't mean that it applies. I can write that my rules apply to everyone in North America too. Only the insane would believe that. And even if I had men with guns willing to carry that out and make you comply, it still doesn't make it apply. There's no obligation. So again, we have the first logical fallacy, circular logic. The second one, just as common. The second logical fallacy he will use is called proof by assertion. They think that just because they say it, it's true. And just because other people say it, it's true. And that if they say it 1,000,000 times, by the power of Odin himself, maybe Zeus. We'll get Jupiter in there too. Why not? Saturn. It'll make it so. We have all these gods. No. Proof by assertion. Doesn't matter how many times you say it. So what does he do? You can see it right there. Within Canada, you are subject to the laws of Canada. So, where's your proof? We already know that. Stop repeating it. The second part of that sentence is similar to what I was talking about in Government Indicted about the trauma bonding and how they hurt you but give you things to create a bond. It's the Stockholm Syndrome. Within Canada, you are subject to the laws of Canada, and you are also entitled to the rights, freedoms, and protections provided by those laws. Well, first of all, we have the proof by assertion. You just repeated your argument. Doesn't make it true. Second, your legal opinion here is not true because the duties of allegiance and protection are not created when you force people to pay you under threat of punishment. And yes, even in Canada, you don't pay taxes, you go to jail. That's the threat anyway. So keep that in mind. So now we'll get to the third logical fallacy that he does. So despite only presenting a proof by assertion fallacy and a demonstrably false legal claim, our valiant prosecutor now makes what's called an unwarranted assumption. Because without a single fact supporting his claim that the Constitution applies to you just because you're physically in Canada, he now assumes he has proven that by quoting the text. So here we go. The Federal Income Tax Act, the ITA, states that every person resident in Canada, wow. Every person resident in Canada at any time in the year is to pay that person's taxable income tax. So he presumes his claim is true that the Constitution applies because he's physically in Canada, and then moves on to read the text as if that was relevant, which it is not until you prove your first proposition. He then presents several things, some factual, okay, some are factual, some just opinions. But as you see, something may be factual, doesn't make it evidence. Because it's got to be relevant. It has to have a tendency to prove the proposition. You filed your 2010 and 2012 income tax returns as a Canadian resident in Alberta using a Canadian address. Well, filing a return is factual. Whether he was a Canadian resident, that's not. That's a matter of opinion. Did he use a Canadian address? Yes, that's factual. You have a Canadian social insurance number. Factual. You earn taxable income from Canadian sources, including Canadian employers, as shown by your T4 slips. That he earned taxable income is a matter of opinion. Canadian sources, that's factual. Canadian employers, factual. Shown on the T4 slips, that probably is true. Now we get to the opinion. All these factors indicate that the ITA applies to you. But there's an if for that. If you have proof that the Constitution, a written instrument from 1867, applies to him just because he's physically in Canada. But let's break this down even further. Filing a tax return is compulsory. You do it, you go to jail. There's the threat. You either pay or go to jail. So forcing strangers to give you money under threat of punishment does not make a written instrument apply to others and create obligations on them. It just makes you a crook. That alone negates the second part about the insurance number, because that's also compulsory. And also, how exactly would having a social insurance number or filing a return prove the Constitution applies to you? No one can explain that. If you're a critic and you think that it's easily explained, by all means, present your evidence. But what we're exposing here is the cart before the horse. The cart before the horse fallacy. The logic is backwards. It's just like when you say, "Where's your evidence? Your Constitution applies to me," and they say the code. Well, the Constitution is supposed to be the authority for the code. They're putting the cart before the horse. Whether the income is taxable is also a matter of opinion. It's not a statement of fact. Being taxable is entirely dependent on the Constitution applying, which the prosecutor here has completely failed to prove. And to throw out, he also, and he would think that, and CRA agents believe that just because I receive money from a Canadian source, from people in Alberta, Toronto, and whatnot, that means their Constitution applies to me in the fortified compound in Phoenix, Arizona, Mesa, Arizona. And I've asked members of the CRA, agents there, I've asked Department of Justice attorneys and prosecutors, I've asked MPs, I've asked law professors. At least Robert Diab was the only honest one who admitted there wasn't any evidence. Just a blunt assertion of power. Criminals make blunt assertions of power. So his claim that all these factors indicate the ITA applies to you, all he has is proof by assertion fallacies. He makes no attempt to use the return or the Canadian address or the source income to prove the Constitution applies. See, that's not even in there. And that was the question. So it also keep in mind that this prosecutor is not making these are not his personal claims. All he's doing is trying to prove the claims of these Canadian Revenue Agency employees. That's his job as a prosecutor, not to make his own arguments. He's there to prove that the arguments made by the CRA are true beyond a reasonable doubt. That's what they do. And he doesn't want to tell us what the names are. So I don't think it's a harmless oversight. I really don't. So I don't think it's a harmless error. The letter was pretty short, so he had the opportunity to present the name of his witnesses, and he's refused to do that. So this completely debunks this prosecutor's position, his arguments, and it is definitely prosecutorial misconduct and obstruction of justice. He is now committing more crimes, actual crimes that are hurting a peaceful man. It's prosecutorial misconduct and obstruction of justice because he is knowingly arguing without evidence, and he may actually argue like some have. We have one from Saskatoon that there's a call to shame with, that believe that maybe it's because of Odin, Zeus, who knows, that they can argue without evidence, and that's fair. And that not only are they arguing without evidence, it's irrefutable. No, that's prosecutorial misconduct. That's dishonest. That makes you a criminal. It's completely unfair to argue without evidence on a practical application of law, lie saying it's theoretical, and then hold that it's absolutely irrefutable. That's a rigged system. You're a crook. I don't care if you use the word honorable in front of your name. So I think that completely discredits. So we had the circular logic, proof by assertion fallacy, and we have a unwarranted assumption. But if you think that I've made an error in my analysis, that I have not completely debunked this, and shown how easy it is to debunk it, so that even a layman like myself, with no training whatsoever, can do it, please, we do a live show most Saturdays, and now it'll be a live stream on YouTube every Wednesday afternoon. Present your evidence. Show me where I have a gap in logic. Show me where I've made assumptions. Just show me where it's wrong, and I'd be happy to address that. Again, if you've got evidence proving a written instrument from 1867 applies to me because I received money from someone in Toronto, I'm all ears. I want to hear it, because you can do what this prosecutor and no one at the DOJ so far has been able to do. and that's provide evidence that this written instrument applies to me just because I received money from someone in Toronto, or if I'm physically in Toronto. If you've got the evidence, I'd love to hear it. My name is Marc Stevens. This has been debunking a prosecutor's claims that they, the website is markstevens.net. If you've got evidence, please, I'd love to hear it.